Hello and welcome to the daily newspaper analysis. Today we shall be discussing the newspaper of the 17th of February. So coming to the first article, water equity. Now the context here is that just yesterday the Supreme Court has given a final verdict on the Cauvery river water sharing. So this is a landmark judgment. It is a historic judgment because this issue has been a festering one. It has been continuing for very long. So that is the relevance here. That is the context. Now coming to first and foremost some background aspects. Firstly, you need to know something about the river Cauvery itself. Now, Cauvery river is a peninsular river. It is a perennial river. It is a river with a length of 802 kilometers and it originates from the foothills of the Western Ghats. Now, suppose these are the Western Ghats. So, from here, it originates in the state of Karnataka. Then the riparian states are, that is the states through which this river is passing. One is Karnataka, as you can see in the map. The second state is Tamil Nadu. Also, here is Puducherry. So that is also constituting one amongst the riparian state and is also a party in this judgment of the Supreme Court. Another state is the state of Kerala. This is important because a number of tributaries for Cauvery river are originating in Kerala. So Kerala constitutes the catchment area base of this particular river. So that is something that you need to know in particular about the Cauvery river. Now coming to the beginning of this dispute. Now this water sharing dispute between Karnataka and Tamil Nadu is something that is very old. It is from the time of the British era when India was not independent. At that time, Tamil Nadu was largely the Madras constituency and Karnataka region largely comprised of the Mysore kingdom. So that you need to know is the historical aspect. So in this regard, some agreements was what was made during the British era. One agreement was in the year 1892 and later an agreement was made in the year 1924. Now here you need to know that because Karnataka formed the Mysore kingdom, whereas Tamil Nadu formed the Madras presidency, which was directly under the British rule. So it was said that often the Britishers had a tendency to favor the Madras presidency more than the Mysore kingdom. So this was the birth of this problem that Karnataka felt that it was discriminated against, and this problem continued unabated even after independence. So that is the history of this particular issue, the historical aspect. Then this problem continued for quite some time and this led to finally the formation of the Cauvery River Water Tribunal in the year 1990. Now this tribunal was formed under the Article 262 of the Constitution. As per this Article 262, it is the Parliament which is mandated to make a law with regards to any interstate river water dispute, and the Supreme Court and the High Court cannot intervene here. So that is something that is a constitutional mandate, and so under this particular article the tribunal was finally formed in the year 1990. However, for long this tribunal did not give a judgment. It was after almost 16 years that the judgment of the tribunal came in the year 2007. So that is something that is important. However, despite this delay in the judgment also, this judgment was not notified. And it was only in the year 2013 that finally the government notified this judgment, that too after a direction given to it by the Supreme Court of India. So that is something that is important. This final verdict of the tribunal was also not accepted by the riparian states, that is Karnataka, Tamil Nadu, Puducherry and Kerala. All the four states objected to this judgment and they said that they will go to the Supreme Court. Now what is important for you to understand here is that under this article the Supreme Court and High Court cannot intervene. However, in this case specifically, the Supreme Court, under the special leave petition of the Supreme Court has taken cognizance of this matter and going outside its set norm, Supreme Court has intervened. Now, what is the ground on which the Supreme Court has intervened is with regards to protecting the right of life of people under Article 21 as a guardian of the fundamental right of the people living in these areas and their water rights. In that respect, Supreme Court has intervened. So that is something that is important for you. And finally, the Supreme Court has come up with the final verdict. So this is something that you need to know. Another thing is with regards to the verdict itself, some facts is what you should know. Now, there is a distribution of 740,000 million cubic feet of water in this river. So the short form for that is TMC feet. Now, of this 740 TMC, 284 has been allotted to Karnataka. That is something that you need to know. And also 404 has been allotted to Tamil Nadu. Even if you don't remember these facts, you should at least know that the maximum share has gone to Tamil Nadu, followed by Karnataka. Then the next in line is Kerala, which has got approximately 30 TMC cubic feet. That is something that you need to know. Also, Puducherry has received 7 TMC feet of water. So that is something that you need to know. Some other aspects is what is important, that for environmental protection another 10 TMC feet has been set apart, and also for some inevitable escapes of this water into the sea, 4 TMC has been set by the court. So this is something that you need to know in the background aspect of this particular judgment. Next, we shall be analyzing the important issues with regards to this judgment and the entire controversy regarding sharing of Cauvery river water. Now, the first issue is with regards to a principle of equity. Now, this is a principle which the Supreme Court has mooted in its judgment. Now, you need to understand that often states have been raising claims that if a large part of the river is in a particular state, then that state is going to have a large share of that river. This principle has been negated by the Supreme Court, and the Supreme Court has said that the principle will not be upon the geographical amount of sharing that a state has. Rather, an equity principle will be followed, where every single citizen right is something that is going to be given consideration to, and sharing of water will be based upon the necessities of the state. So this is something that you need to know, that the principle of equitable distribution is what has been advocated by the Supreme Court. Another thing is that the Supreme Court in its judgment has said that all rivers are to be considered as national assets. This is important from the idea of cooperative federalism. Now here you need to know that previously states would say that because a river is passing through its territory, then the state has first right on the river. This principle has been done away with, and now rivers will be considered as a national asset, and the center will regulate its sharing. So this is something that is vital in this judgment. Another thing is with regards to the implementation of the reward of this particular award or this particular verdict. Now in this regard, you need to know that several implementation challenges is what has arisen. This river water sharing will take place at a monthly basis. So some intense implementation issues is what is involved. Some intense administration is what is advocated here. There are some legal and technical framework which will need to be set up to ensure effective implementation of this verdict. So that is one issue important. Another thing is with regards to the ad hoc measures. Now the Supreme Court has shown some faith. It has said that it will hope that the verdict is respected by all, and the ad hoc measures which usually happens as states often rush to the Supreme Court in times of distress, and time and again some temporary norms and rules are being laid in this respect. So this is something that is going to come to an end. Now you need to understand that the judiciary in India is already very overburdened. So if such matters are again and again coming to the Supreme Court, so this is something that is unwelcoming. So in that respect, a final verdict which is acceptable to all is definitely a long-term solution. So that is something that has been advocated here. Another issue is with regards to political partisanship versus legitimate grievances. Now, water is something that is a daily need, a basic need of every individual. And so if water distress is there, then definitely it is going to comprise a legitimate grievance of the citizens. But what is happening is that in India, the issue of river water sharing is not something that is seen objectively, rather it is seen politically. There is a lot of politicization of this issue. Recently, also I had discussed on the 1st of February, please, if somebody is interested, you can go and see our video. On the 1st of February, we had discussed the controversy between Odisha and Chhattisgarh with regards to the sharing of the waters of Mahanadi River. There also we had seen that how the matter has been over-politicized, and this is a cause of concern. So this is something that even the Supreme Court has highlighted, that the matter should not be politicized, so that is important. Another thing that you should have a clarity on is with regards to the aim of both the Supreme Court judgment as well as the tribunal verdict. So the aim has largely been with regards to balancing the competing demands for waters and ensuring that interests of each state is ensured, and also bringing about a pragmatic sharing agreement between the states. So that is something that is important from the aim of these verdicts. So that is vital. Another thing is with regards to a comparison between the tribunal and the Supreme Court verdict. Now, if after the tribunal judgment of 2007 and its further notification in the year 2013, the final verdict has only come in the year 2018. So it is itself raising questions upon the value of the verdict that the tribunal had given. The trust on this verdict was something that the states did not bestow. But what is vital is that even 10 years after this verdict, the Supreme Court has almost adhered to this verdict, except for a minor change of approximately 4 TMC feet of water, which has been removed from the share of Tamil Nadu, and it has additionally been given to Karnataka. Except for this minor difference, nothing much has been changed by the Supreme Court. So this restores the credibility to the verdict that the tribunal had given 10 years from now. So that is something that is important. Another thing is that there was an irresponsible role which the center played. For example, first and foremost, the center did not notify this particular verdict by the tribunal. This was indeed a criticism, and the Supreme Court had criticized the center for this. Also, after this, many other cases that were seen where the matter was politicized by the center itself, and it was seen to take sides with particular states. So these kind of behavior by the center is something that has been criticized, and this is not in the spirit of cooperative federalism. So that is something that is important here. Another thing that you need to know is that the verdict had called for setting up Cauvery Management Board and Water Regulation Committee. This is something that has still not been done, and again the Supreme Court has highlighted that until and unless this management board for the development of the river basin is done, the verdict is going to be not having much significance. So that is something that has been reiterated, that this board should be set up and this regulation committee should also be set up, so that you should know. Another thing is with regards to the finality of the judgment. Now often it has happened that the finality of judgments is not being considered or being upheld by the riparian states. For example, in 2007 also this verdict was given, but the states did not comply with it. So the Supreme Court has now hoped that this judgment is going to be considered as a final judgment, and all states as well as the center will respect this judgment. So that is something that is important for the viability of this particular decision. Another thing is that the judgment is not talking about the distress years and how the water will be shared in times of drought. So that is a major loophole, because largely the conflict is rising in drought years only. So a clear roadmap should have been laid down. So that is something that has been analyzed, and this is a criticism to the present judgment. So that's about this all the issues with regards to this topic. The topic is indeed very, very important. It has been in the past and it still is. So that's the relevance. Now coming to the next topic, the case histories as well as not a prescription for the poor. Now these are two articles which are largely based on the same context. The context here is with regards to the National Health Protection Scheme. Now this was a scheme which has been mooted under the Ayushman Bharat program in the budget of 2018 and 19. Under this scheme, an insurance cover is what is going to be provided for secondary and tertiary healthcare. So this is something that you need to know. And it envisages 5 lakh rupees of insurance cover to 10 crore families, which is almost going to be equal to 50 crore citizens. So this is a huge insurance program, universal. It is in line with the universal health coverage. It will cover almost 40% of India's population, of its economically lower population. So that is something that you need to know in the background aspect of the scheme. Now largely both the articles are highlighting the challenges which this particular scheme faces. So that is the relevance of both these editorials. Now coming to the issues which have been highlighted, the first issue is with regards to a demand side versus supply side issue. Now here you need to understand that there is a demand side which the government is focusing on. For example, if the government is going to provide this insurance cover, then more and more people will demand more health services. So the focus is largely on this demand side, and ignoring has been done of the supply side. Now even if citizens have more coverage and the demand rises, what is important is that there should be hospitals which should be available, and not only hospitals, these hospitals should be available in the rural area. They should be government hospitals. This aspect is something that the government is not paying much attention to. So even if demand is rising and there is no supply, then the cycle is not going to be completed, and adequate health is something that cannot be ensured. So on this ground, this principle is something that is going to fail. So that is one criticism against the NHPS. So here the case is being made that along with the demand side, focus should also be on the supply side and in improving the public health infrastructure. So that is something that has been highlighted. Another thing is with regards to the out-of-pocket expenditure. Now out-of-pocket expenditure, in simple terms, it means that how much am I personally going to spend out of my own income for availing health facilities. Now it was envisaged that this being an insurance coverage, it is going to reduce the out-of-pocket expenditure. And definitely it will, because approximately 5 lakh insurance coverage is provided for secondary and tertiary treatment. But the impact is going to be minimal. Now, why is the impact going to be minimal? Is that because a large share of the out-of-pocket expenditure is largely spent on OPDs. And this aspect has not been covered in the insurance coverage. It also ignores the primary healthcare. So it is the primary healthcare along with the OPD which is the major cause for out-of-pocket expenditure. So until and unless this is addressed, the problem will not be solved. Not only that, even if secondary and tertiary health coverage is provided, what happens is that when a person is hospitalized, especially in private hospitals, then often that person is again charged, some unnecessary tests are done, costs are inflated, as a result of which the out-pocket expenditure of the person somehow does not reduce. So that is one criticism which has been made. Another analysis is with regards to the public health system versus private health care. Now here you need to understand that the scheme, the NHPS, is not something that is targeted at the public healthcare system. It is open for both public as well as private healthcare. Now, for instance, I am in this 40%, this category of 40% of the people who are availing the benefits under the NHPS, and I want hospitalization care, then I can choose to get admitted in a public hospital or in a private hospital. Now, if the quality of public hospitals is not good, or for that matter, the public hospitals are not present as such, then automatically I will go to the private hospital. So this is what has been drawn here, that there is a fear that the private hospitals will curb or stamp the public healthcare system in the country, and the market will be largely focused on the private healthcare. So this is one case which has been drawn here, that the government needs to focus on increasing public healthcare, improving the quality in public healthcare. So that is something that is vital. Another thing is with regards to a regulation of private hospitals. Now, as we've discussed, there might this insurance scheme might lead to a burgeoning of private hospitals in the country. But some regulation is what is needed in this regard. Previously also there have been schemes like the Rashtra Swasthya Bima Yojana and some other state schemes is what has been mentioned. For example, Rajiv Arogya Shri scheme in Andhra Pradesh, or Maharashtra's Mahatma Jyotibai Phule Jan Arogya Yojana. All of these schemes have been insurance schemes in the past, and as from their experience, it has been seen that often they largely benefit the private hospitals, and not only that, it leads to some lack of regulation in the private hospitals. For example, they cause unnecessary tests to the patients, they cause unnecessary hospitalizations. Also, there was a case of mass hysterectomy seen in Andhra Pradesh, where innocent women were made subject to removal of their uteruses unnecessarily just to gain the benefits of the Rashtra Swasthya Bima Yojana. So such kind of unhealthy practices is what has been seen in private hospitals, and this warrants for effective regulation of these hospitals. So this is something that needs to be focused on. Another issue is with regards to the implementation challenges. Now, at present, from this 40% envisaged population, only 11% of the population is roughly having some insurance health cover. So definitely there is a huge gap which needs to be bridged. That is one implementation challenge. Another issue with regards to implementation is that even from the Rashtra Swasthya Bima Yojana, we have seen that this Rashtra Swasthya Bima Yojana only wanted to cover the BPL families, and despite the fact that this scheme was for a lesser number of people, there also implementation was not universal, or it was not 100% coverage for this particular group. So from the past experiences also, what is arising is that this is a hugely administratively intense task, and several implementation challenges is what needs to be surmounted. So that is the analysis. Another thing is with regards to translating the coverage to utilization. Now, it might happen that coverage is provided to 40% of the people, but the benefits are only reaped by approximately 5% of the people. So then the scheme is again going to get defeated. For example, if there are no public hospitals in rural areas, and large section of this 40% of the envisaged target group is in the rural areas, then definitely only a small section will be benefiting. So that is something that has been raised here, that the government will be paying premiums for 40% of the population, but the benefits will only be reaching to a small section amongst these people. So that is one cause of concern. There is a need to focus on ensuring that coverage is also translated to utilization of these facilities. This also calls for a behavioral change amongst people, because it is seen that in rural areas people still are not very health conscious, and they do not avail secondary and tertiary health services. So this behavioral change is also that needs to be ensured. So that is an analysis. Another issue is with that of cost inflation. Now, often it happens that whenever the government comes up with such kind of a public funded healthcare scheme, what happens is that the private hospitals immediately raise the costs of services. So this is something that needs to be checked, because if at present 5 lakh rupees is what the government is going to provide, but this is also going to be followed by a price rise in the private hospitals, then the amount of services that a citizen can incur within this sum of 5 lakh rupees is going to be minimal. So the entire purpose of this insurance coverage scheme is what is going to get defeated. So that is something that has been analyzed. Another analysis is with regards to a hospital induced demand. Now this is something that is again important. Now the demand should rise from the citizens themselves, and it should not happen that this demand should be forced on the citizens. Largely what happens is that because of such public funded schemes, the private hospitals create an artificial demand by unnecessary diagnostic tests and all such kind of issues. So that is something that needs to be curbed. Another analysis is that the scheme is being called as Modi Care on lines of Obama Care in the US. Also, it is being hailed as a next generation health security scheme. Now, definitely it is a major step forward. That should be your final opinion also. But indeed, this scheme is not a panacea to solve all the health care problems within the country, and definitely it is a good step, but some followed steps is what is needed. For example, reforming the public health system, creating more number of doctors, addressing the supply side constraints is what is necessary. So that is the entire gist of this particular analysis. This scheme is very, very important both for prelims as well as for mains. So that is the relevance. Now, coming to the next articles, science should have the last word. Now, the context here is with regards to a scientific temper which needs to be built in the society. Now, this editorial is largely an important one because sometimes we have a tendency for general studies paper 3, we largely focus on some scientific developments which happens. But the question sometimes is not on these developments, rather it is a basic question that how can you build scientific temper? So that is the relevance of this particular editorial. Now, coming to the issues which have been analyzed here, the first issue is with regards to the scientific temper itself. Now, you need to know that this was an idea of our first Prime Minister, Pandit Jawaharlal Nehru, that India should be a country of scientific temper. This has also been enumerated in the fundamental duties under Article 51A of the Constitution, that it shall be the duty of every citizen to inculcate scientific temper. Now, what do you understand by this term scientific temper? Now, this is something that is important. This definition is what has been taken by Pandit Jawaharlal Nehru's book, The Discovery of India. So this becomes important for you. I have mentioned these points here. Please make a note of this. Whenever you are supposed to describe or explain what scientific temper is, you can repeat these words here. Now, scientific temper would largely comprise of some appreciation of the facts of an issue. It would comprise of having a more critical faculty. It will be weighing of evidence. It would also be with regards to an issue of tradition. It would question tradition and it would not follow tradition just because it is tradition. So that is something that is there, that some critical thinking is what is going to be inculcated even in the following of religious and traditional practices. That is something that comprises of scientific temper. And for fulfilling of scientific temper, what is required is political and economic freedom, because when political and economic freedom is available, it is only then that all the above facts can be implemented. So that is something that you need to know with regards to scientific temper. The second analysis that has been made is with regards to the current status in the country. Now, it has been 70 years since independence. It has been 70 years since Pandit Jawaharlal Nehru saw the vision of scientific temper, but still the country does not have adequate scientific temper is what has been mooted in this editorial. For example, even today, traditions and rituals is something that is given a huge emphasis upon. Cases of cow vigilantism is something that is prevalent. Also, there is a killing of rationalists in this society. So all of these are somehow a bad commentary on the spirit of scientific temper in the present times. So that is something that has been analyzed. Another example which is important, which has been given, and if you use such examples in your papers, it provides a newness to your answers, and this is something that UPSC will reward. For example, a case of Bermuda Triangle is what has been mentioned here. The Bermuda Triangle, for those of you who do not know, this is a triangle which is formed between Puerto Rico, Bermuda and Florida, and it is believed there are some superstitions with regards to this region. It is believed that it has some alien impact or it has some other spiritual impacts. So such kind of rumors is what are spread. So even in the case of Bermuda Triangle, the editorial discusses that none of these superstitions was something that could be proved scientifically. So that is one example which you could use, that even in the present times, scientific temper is not well developed. So that is one analysis. Another issue is with regards to solar eclipse. Now, there are many superstitions in India with regards to solar eclipse. Here, I would like to mention that a case can also be made with regards to the media. For example, whenever there is an eclipse in the country, instead of showing on news channels the scientific aspect of the eclipse, that how the eclipse happens, why it happens, instead of focusing on those areas, even the mainstream news channels are focusing on the superstitious aspects. For example, they will have astrology shows with regards to the impact of solar eclipses on the zodiac signs. So this is some irresponsible behavior which is happening in the society, and it is a very common trend. So this is something that needs to be checked, is what has been analyzed in this editorial. Another analysis is with regards to the mythology of India. Now, this is important. In the mythology, there is a mention of Pushpak Viman, the Brahmastra. It is often said that the Pushpak Viman is the birth, is something that is the core of the development of the aviation industry. The Brahmastra is somehow related to the nuclear weapons. Now, all such kind of comparisons is something that is not scientifically justified. And why am I saying that this is important is because on the 100th National Science Congress, such kind of examples were quoted by the Prime Minister himself and other politicians also. So this is something that becomes an irresponsible behavior. It is something that is against the spirit of scientific temper, because all of these ideas of Pushpak Viman and Brahmastra cannot be justified. So some objectivity is something that is required here, which is not there. So that is something that can be used as an example. Also, some recent controversies with regards to scientific temper is what is important. Now, some politicians recently had said that the Darwinian theory of evolution is junk. They criticized this theory and they said that this shouldn't be taught in schools. Also, in the past, some politicians had made a case that cigarettes are good for the health and there is no scientific evidence that cigarettes are causing any kind of cancer. So such kind of issues often emerge, and they emerge from the parliament itself. So this is something that is unwelcoming of a country which has scientific temper as a part of its fundamental duty. So this is something that has been advocated here. These examples are very, very pertinent. They are very, very relevant. They are very practical, which you can use in your answers. So that is the relevance of this entire editorial. Now, based on today's discussion, please try and attempt these questions within a word limit of 150 words. So that's all for today's discussion. I thank you all for watching and I hope to see you tomorrow.